Law School Secret Series, Criminal Law number 5, Basic Categories. Welcome, glad you're here. As always, be the change you wish to see in the world. Recall, law school requires that you do your own research. I'm going to continue to review the concept of mens rea and add upon it. Criminal liabilities, recall that the elements of the crime are acts rea, mens rea, concurrence, causation, and a resulting injury or crime. Again, here's what you want to have uh, in your outline, and we're going to cover the mental elements and liability, criminal liability. Okay, so proving state of mind, culpability, or blameworthiness is necessary for the prosecutor beyond a reasonable doubt. Distinguish mens rea from motive. Sometimes motive is discussed, but that's a separate category. Now, with the Model Penal Code, MPC, they use purposely, knowingly, recklessly, or negligently. There are also categories of general intent crimes, which will use purposely, knowingly, recklessly, and negligently, and some courts hold mens rea can be inferred based on the act. With the specific intent, all you need is purposely and knowingly, and that would be purpose or substantial certainty. It might not be inferred by the act. With transferred intent, this is a legal fiction borrowed from torts. There are malice crimes that are specific intent, except the felony murder rule and res geste crimes. Mens rea is not necessary to prove with strict liability. Mens rea is not necessary in killing an officer when you're resisting arrest, and it's not necessary with the the felony murder rule. Now there's a case, Regina versus Tolson, and it was in the UK, and it was an appeal case of a woman convicted of bigamy, and she used the mental state because she reasonably believed that her husband was dead, and he had went missing 6 years earlier, and someone told her that he'd gone off on a ship and died. Well, after she got remarried, the husband showed up, and she was convicted of bigamy. And here in the appeals case, the court elaborated on the state of mind, mens rea, and basically this set the precedent early on the no single mens rea because it detailed the different applications. Just anyhow, with Morissette versus United States, that was a case that was appealed where Morissette was out on federal lands, so it was in the jurisdiction of the federal courts, and he was charged with larceny for taking some heaps of metal, and he said he didn't intend to um, steal. He thought it was trash, and they uh, they basically said that they had to prove mens rea, which they didn't in the lower court, and they couldn't impute it or assume it in this case because of the application of law. Okay, so you've got to say mens rea is about culpability, and it's looking at the conduct of the defendant, the circumstances, and the results. Now, with common law statutes, you may use maliciously or intentionally. Now, in an attempt to define mens rea, courts are divided and combine legislative terms into three major concepts: intent, knowledge, and recklessness. On the other hand, the MPC rejects the traditional terminology such as specific intent and general intent, contending that there are four separate recognizable states of mind: purposeful, knowing, reckless, and negligent. Now, here we have the model penal codes details. Let's start with purposely. The defendant's conscious object is to engage in conduct that causes the result. A perfect example of this is State versus Stark, the Washington Appeals Court. Stark had AIDS. He was told that he had AIDS by the doctor, and the question that came before the court on appeal was, did he infect people with AIDS on purpose? The victims, the witnesses, and the medical personnel all testified in court on appeal as well, because Stark was trying to overturn his conviction on several counts of infecting people with AIDS on purpose. He lost that appeal. They um, they uh, they say that purpose is they desired to get them infected. The medical personnel uh, and documented when he was told he had it, documented and expressed that they informed him to have protected sex, and then he engaged in sex with people after he was infected and did not use protection, and they subsequently got it. Okay, well, now let's jump over to knowingly. Defendants aware that the conduct is likely to cause the result, the nature of attendant circumstances, if result of defendant's conduct, and is practically certain in awareness it will cause the result. People versus Canaan, Colorado Supreme Court. Defendant wrote a bad check and it bounced in 72. Now, on appeal, the court ruled that there's no presumption that the defendant knew that the check was short of the money and that the check was bad. In other words, that would just assume that were knowing their bank balance all the time. Okay, so recklessness is another one. Defendant consciously disregards the substantial and unjustifiable risk that the conduct causes the results. State versus Peterson, excuse me, or Appeals Court, 1974. This was a street drag racing case where he tried to avoid the accident at the last minute, and he used that as saying that he wasn't reckless because he was trying to stop it. And the court ruled that the activity he was in, he was not effectively withdrawing, and he was found guilty of the death of one of the other people that died in the crash. Okay, negligently overlaps a lot with recklessness at times. Sometimes they go hand in hand, sometimes they're alone. This is where the defendant fails to perceive a material element of inherent risk of the offense, and the material element results from the conduct. In the Gian Cusio versus State of Florida Appeals Court, a therapist was found criminally negligent in the death of a patient, Mozan. Mozan had tuberculosis that was dormant, but it reactivated, and a regular medical doctor advised the patient to go to the hospital to get on meds and get better. But Mozan, the patient, refused and instead went to this therapist that believed in an alternative therapy that involved fasting and a vegetarian diet to cure the infection. Now, Gian Cusio said that they made a good faith effort and that they weren't intentionally causing the patient to die, but the court found that since they did not follow the common practice, and it wasn't an approved therapy for treatment of the disease, that they were criminally negligent. Now, transferred intent is another area. Perkins and Boyce, in their Horn book, opened by saying transferred intent is legal fiction. At common law, burglary is the breaking and entering of a dwelling of another in the nighttime with the intent to commit a felony therein. Here, the law uses felony, any felony, to transfer intent and satisfy the mental element of this crime. Homicide, as a consequence of a felony, even if intentional, can create a fictional transferred intent through the criminal act. Recall that the felony murder rule. Even though a person may not intend to kill someone, crimes such as burglary, arson, rape, larceny, through their inherent risk, create what is called malice aforethought. However, if intending to commit a crime of one kind and accidentally, through chance, for example, let's say you borrow a coat from someone and there's a handgun in the pocket, you would not be found guilty of carrying a concealed weapon, because the intent in that type of case, it would not transfer. So if Joe intends to burn down his ex-wife Mary's home and he sets fire outside near her house, intending to have it catch on fire and burn down, and the wind blows and spreads the fire over to her neighbor Kyle's house, burning it to the ground, Joe's intent to burn Mary Ann's house still will be transferred to Kyle's burned home. Joe will be guilty of arson. Transferred intent and MPC continued. MPC Section 2031B requires proximate cause, and common law cases are treated as causation. Did the defendant cause the result, rather than did he intend the result? Now, the felony murder rule rests upon the doctrine of transferred intent. This rule was meant to be a deterrent to felony crimes during the time when people were often killed for crimes. That is, there certain crimes like burglary would have been capital offenses. They're going to hang them or whatever. But now there's less capital punishment, and 46 of the states, it's called first degree murder. So here's another case: Regina versus Smith in England, 1855. A defendant meant to shoot and kill a person other than the person that he shot. In other words, it was dark. He thought the figure in the distance was the person that he wanted to kill. He shot them, he killed them. He was convicted of murder on appeal, even though he did not intend to kill that person. He did kill somebody, and they used that transferred intent doctrine. Until next time, we're going to look at some other areas. And remember that attendant circumstances are often required, and they have to exist during the time of the crime. And malice, the idea of malice as a volitional act without a legal excuse or justification, and malice can carry other connotations such as malice aforethought in the murder. And remember, scienter or knowledge is cure for the void for vagueness doctrine. Next time, we're going to try to review concurrence more in depth and causation more in depth, because they can pick those apart in court. And recall, maybe you want to look at some vicarious liability cases. This is the U.S. Arthur Anderson, where the accountant was initially convicted of being vicarious liable for the Enron scandal because of destroying documents as the accountant. But on appeal, it was overturned, in 2005. Okay, well, with the Pinkertons rule of liability, um, this is where all the co-conspirators or conspirators to a crime can be held liable for each and every crime that is reasonably foreseeable in furtherance of the crime. And sometimes this is like where the felony murder rule can come in with it, or let's say you do some reckless activity and somebody dies, or you do a robbery and one person's doing the getaway car, the other person's, you know, in other words, they conspire to do something and then something goes wrong, someone gets shot, they're reckless, kidnapping, whatever it is. All of the co-conspirators, even if they're not there, um, can be held liable. Now, this is our outer outline. You will fill in your elements of the crime. You will know and memorize all the definitions so you can apply the law to each case. Categorizing it by crime. First, start with your elements of the crime, that's the fundamentals, and then you get into, is it a crime against a person? Is it a assault, battery, mayhem, kidnapping, um, rape, homicide? And then look at your defenses, excuses, and then you look at crimes against property, larceny, burglary, robbery, embezzlement, false pretenses, arson, receiving stolen property, larceny by trick, the specific and the sack crime, solicitation attempt, and conspiracy. Now, until next time, continue to add to your outline, review the subjects, memorize them, do some practice exams if you have time, and of course, do your own research and like, comment, and here's the references if you want to look at those books. And as always, thank you so much for stopping by. I hope that you get something out of this and have a wonderful week. Take care.